Can you all hear me?
Hi, Rayan. Adele, how are you?
Hi. Well, and yourself, Adele?
Yes, I can, sir.
Good.
Yes, you can.
Okay, cool. I just, the protocols that you normally introduce now for, the usage of the mic and the video screen and the attendance register and all of that. Are you going to do that quickly, or
I'm just going to. Do we have new students? No, not that many. Okay.
Yeah.
Not many, yeah.
Basa, you? Basa, are you new?
Oh,
Fatima?
yes, I am.
Okay, welcome. Fatima, are
Yes,
you new? Oh, welcome. I'm Adele from UNISA. So, already started the recording, so I just want to make sure you all understand where the chat function is. I'd like you to post your student number in the chat function. For those of you who are new, you've got a bar, and I think it's that black bar with a red leave tab on the right-hand side, and then you get a little hand, and Rayan will explain if he wants you to use the hand, but I just need you to know that between the hand normally and the two little people, there's a little text box. Looks like a text bubble. You click on that, you open the chat box, and then you can just enter your student number there. I will also post an attendance register that we like you to complete. And towards the end of the session, if you just complete the feedback form as well. And then we keep our mics and cameras off. It saves you data and it improves the quality of our reception. So, Rayan, if there's anything else you would like to explain, you are welcome to. There's just the last thing from my side, the one-on-one sessions that you can have with Rayan will start soon. We are almost done with the platform, but I think you should be receiving your first query form that you can complete. And if you have a specific query that you would like to address with Rayan on your own, we call those one-on-one consultation sessions, then you can have a session like that for approximately 30 minutes with Rayan on your own, and you will organize a time. You will choose your method of this one-on-one session, whether you want to send a query via email and Rayan responds, or do you want a call on the Teams platform like we are doing now. So you can chat about your query. That will be available definitely in this week. So, Rayan, over to you. If there's anything else, you can just call on me.
Thanks so much, Adele. Yes, I'm happy to hear that it's coming. I'm looking forward to getting that, make it more convenient for me to set up meetings with students directly. Yes. So cool, man. That's a good development. There was one student in class last week. And we spoke extensively on, skills and so on, some study skills and approaches to the course. But look, this is simply more, although this is a facilitation session, I will be speaking about general study skills and study methods and things like that. You should, if you're having difficulty with the work, approach me for individual sessions, okay? We can start off by just testing the waters. Have you set your date? Do you know when your exam is going to be? Nobody knows when the exam is going to be written?
So we don't know if it's going to be online or venue-based. Okay. They still need to send us the final timetable.
Okay. All right. So we're waiting on that, eh? Well, it's, I mean, all the other institutions who I'm also lecturing tell me the same thing. But most of them are saying that the exams are going to be like a type of take-home exam, and it's going to be done online rather than, a face-to-face, in-person exam written at the premises. Okay, so my name's Rayan. Welcome to it. At least I know one of you who was in my class before. Lizzie, welcome. You just joined us. Nosipiwo, welcome as well. Basa and Aisha. So, how are you guys finding the course? Has there been any difficulties on this with the course? For those of you who've been in my classes before, my face-to-face classes, tutorials that is, I encourage people to ask questions. It's not just me talking all the time. I really like to hear from you and for you to try and explain, your difficulties that you're having, things that you're having, problems with, concepts, and so on. Okay. So, has everybody already submitted the first assignment?
Yes, we have.
Alright, that's cool. And
yes,
when did you? Okay, lovely. So your feedback on that? You haven't received the feedback, the marks yet?
No, received
not
nothing
at
yet.
all.
Okay, because this is not such a bad subject. It's actually like what, 6 modules or so? 6 to 7 modules for the whole semester. And but the concepts, I see many students have a difficulty understanding some concepts, So just let me give you a test this evening before I get into the basic study skill methods and things like that, which I'll explain along the way. Okay. Let us do a very practical exercise. Okay, and see if we can perhaps just move to the assignment and see. I can also see from your responses, like your understanding, your levels of understanding. Let me try and share something here. Okay. Now this is, can you all see this? I'm sharing my screen with you now. Can everybody see this?
Yeah, we can
Yes.
see it. I can see.
Okay, cool. That is assignment 1, which was due on the 23rd of March of this year. So this was from the first semester. But don't underestimate these assignment questions, guys. They normally get repeated not in the exact same way. They do get repeated in the actual exam in more or less or similar terms, So it's important actually to cover as part of your revision, and even as a general way to see the kinds of questions that they ask in the exam, to look at past exam papers, to look at past assignment questions, because they definitely, remember, UNISA covers subject areas, guys. Okay, this covers subject areas. So introduction to labor law, this is all in that. So let us, I would say, as a starting point, would like to read this question for us now. But everybody can see it, right? So take your time then. This is not a face-to-face. I guess you don't need to do it. So Fred works for Easy Electricians. He is called to a client's, Mr. Riba's house, to fix an electric cable. And although he is not allowed to smoke at any client's house, he lights a cigarette, he fell on the carpet and set the house alight. The whole house burnt to the ground. Mr. Riba is devastated and claims damages from Easy Electricians, which denies, or we should say, who denies any responsibility, because they said Fred was not allowed to smoke, and since he did, he must pay for the damages. Advise Mr. Riba on who he may hold responsible for the damages he has suffered and why. Typical labor law question. This kind of question will come in the exam, in some form or the other. So I say it's a very common question. And let us just see how well you've covered the work so far. Any suggestions on answering this question? The question you need to answer is, advise Mr. Riba, that is the owner now, who he may hold responsible. He's trying to hold the company responsible, the employer responsible, but they are denying it, and they're saying Fred was not allowed to smoke. And since he did, he must pay. So there's a dispute between the employer, Easy Electricians, and Fred. So let me hear from you. What do you think? You think they'll be able to? What will happen? Do you think? Will they be able to? They're trying to hold the company liable. Company saying, no, it's not our fault. You can't hold us responsible. We didn't tell Fred to smoke. He's not supposed to smoke anyway. Where, in what context? What's the big subject? What's the key concept that comes to mind here? Yes, Mbasa.
Well, I think that Mr. Riba, the one who was smoking.
Yeah. No, Fred is the one that was smoking. No, Fred was the smoker. He was the worker. Mr. Riba is the person who suffered.
So, yeah. So Fred is the one that smoked. So Fred is under the company which is Easy Electronics. So on my verdict, I think that it's the company that is held liable for the damage because the worker is working under the company.
But the company didn't tell him to do that. So, I mean, are you saying that the company can somehow be held liable for something that it didn't do?
Yeah, that's a good question, though. But isn't that
Okay, one second. Okay, wait, Mbasa, you that definitely Lizzie. Just give Mbasa. Is that it, Mbasa?
Yeah, it's fine.
Okay, let us hear from Lizzie there. What do you say, Lizzie?
Sorry, Mbasa. I just wanted to add, I think the starting point will be to find out if the company has got any rules in place against smoking. I think it already says that he's not allowed to smoke. So Fred, in an instance, actually broke a company rule. I think that's the first part. But the company still needs to be held liable because Fred works for the company. So they can then take action against Fred, but Mr. Riba can still sue the company.
Yeah. So, okay. So, what is your way forward then? What is your way forward? What did you tell Mr. Riba? Mr. Riba doesn't care now. So, Mr. Riba just wants someone to pay for his damages, I would imagine.
But if I was I would tell Mr. Riba to actually lodge a claim against the company, whether it's a civil claim, but lodge a claim against the company.
And what will be the basis for that? Yes, okay, you onto something there, Lizzie, for sure. For sure, you're onto something, but the company is now objected to this claim. It's saying, how can you hold us liable? We didn't tell the worker to go and smoke on site. We weren't there. It's not our fault.
There is actually a term for it. I actually forgot what it was, but I know I read about it. Where it says the employee can be held. Let's say you are driving a company vehicle and then the employee enters into an accident with a company vehicle, but is not allowed to carry passengers. They can still be like, I can still sue the company because technically he's under the
company did nothing. Yes.
But I don't know. I can't remember the name.
Okay, but yeah, your thinking is there, but now in an exam question or test question, you need to, you need to make the proper references to that. Okay? What do you say, Fatima? Or Aisha?
I agree with
Fatima,
him.
go ahead. You agree with him, okay?
I do agree with him. Because it's not the company's fault, but the company needs to take action against Fred because he did break a law. So they could possibly give him a hearing or dismiss him for breaking, because there are policies with regards to the employer breaking the employee's rules. But other than that, Deepa can definitely sue the company for the claims. And then the company has to somehow get it from Fred.
Okay, okay. Now, this is what an exam memo to a question like this will typically sound like, okay? An exam marking memo, the answer memo. There's main points that the examiner will probably look for now and see, okay, you know, have they covered the right bases? Because you've mentioned a few things, guys, that will get you a mark or two here, but you're not actually striking the point exactly. You have to be a bit more accurate. Any further input before we discuss the answer, maybe? Further suggestions on the answer? What do you say, Aisha?
I obviously agree with him, but I honestly can't say with regards to the guide. I am struggling there, but
Okay, okay.
so
Maybe you
it
can,
was
book the session on that
difficult.
later.
Yeah.
Okay.
With regards to the law, how to put the law terms into context with an example like this. It was kind of difficult to actually do the assignment, but yeah, I completed it. So I'm actually looking forward to what my results is going to look like.
Remember, this was a semester one. This was a semester one
yes.
question. Okay, so
no, I know. I'm just saying I'm eager for my feedback on my assignment, just so that I can have an idea of where but this information sessions is actually going to help because like I can see everybody's understanding is there, but the actual law context is a bit of that's holding us back a bit.
no worries. Now look, okay, we'll just leave anything. Do you have anything to add, Melissa?
Yeah, so I'm pretty familiar with the question. I would agree with what everybody else has said. Yeah, I agree with what everybody else has said.
Okay,
I just want to
guys.
find out the points that would be looked at in an exam.
Okay. So we are required to advise Mr. Riva on who we may hold responsible. Now, have any of you come across this term? You know, it's a legal term called a delict. Has anybody heard of that?
No.
Not.
No, okay. So that is why perhaps, you know, you know, the legal terms may look so distant to you and, you know, you don't come across it. Basically, like, you know, it's something that you do, civil wrong, okay? To understand what a delict is, it's good to know what a crime is, okay? So a crime is an act that is committed that is unlawful. In other words, it is an act that the state considers to be unlawful. Okay? It is unlawful that the person is done, an act that is done, an unlawful act that he has done either intentionally or negligently and caused a result that is forbidden. Okay, like for example, murder, the crime of murder. The crime of murder is defined as the unlawful and intentional causing of the death of another human being. Okay, so this means like causing of the death. You must prove, the state must prove all of these things and must prove that the person knew that it was wrong, he knew there was a law, a rule against it, and he did it with a certain mindset, with a certain, you know, with an intention to cause the death of another human being. Okay, and that is a crime, that is a murder, right? Now, how is a delict different to that? A delict is when you do something that's wrong, but the state doesn't say that it is wrong, so much so that the state will interfere. Okay, I'm just giving you a very brief background so that you can understand this whole thing, because it will come up in other things in labor law as well. So a crime is what the state considers to be so wrong that it will intervene, it will interfere. If you cause the death of somebody, the state will intervene. What will happen? They will arrest you, they will charge you, they will bring you before courts, they will try and prove your guilt, they will try and convict you, and then if they succeed in that, then they will sentence you. That's what the crime is. Okay, a delict is a civil wrong. It's something that you've done wrong, but the state won't necessarily interfere. But you, the party who has been wronged, will have to take steps against the person. Okay, and it's an act that you do that is wrongful and that you caused, and what you caused was damages in the form of financial damages, pecuniary damages to the victim or to the person. Is the object of your wrong behavior now. Sounds a bit complicated, but can I give you an example of how this works? Okay. So let's say you are driving your motor vehicle. Okay. You've been drinking, and the blood alcohol limit, or the alcohol limit in your blood is high. Okay, you're not supposed to drive a motor vehicle with a blood alcohol limit of higher than 0.05 milligrams. Okay, so you're a bit tipsy, you're driving, and you take on your cell phone at the same time, you're busy texting, and you don't notice there's a car ahead of you that's waiting at a red traffic light, and you collide right into the rear of this vehicle, causing damages. Okay. Now, what has happened was the police are called to the scene. Okay, you've been driving with drunken driving. Basically, you've also caused damage to another person's car. You've also caused damage to the person's body. Now what? Police come. Can they arrest you? Can they charge you criminally? Of course they can charge you criminally. What crime did you commit? It's a crime to drive, to be, drunken driving, to be driving with your blood alcohol limit above a certain amount. So they will charge you, they will arrest you firstly, they will then get the evidence in the form of a breathalyzer and also a blood test, and to confirm their suspicions, and then they can charge you and say, well, now you're going to be arrested and you will appear in court, and the whole criminal process will start. Okay? The victim, the person who you collided into, is very happy about this. He's going to get justice now. He doesn't do anything, but the state intervenes. They're going to take the matter to court. There will be the state, in the form of a prosecutor, will prosecute that person, right? So that is fantastic. You're going to get punishment now. All your other rights come into play. But now the victim turns to the police once again and says, okay, I'm happy this person is going to be, charged and hopefully convicted in court and found guilty of that crime. But now look, I've also suffered damages to my vehicle. My vehicle is now badly damaged. Can't you arrest him again and tell him that if he doesn't pay me my damages, that you will have him charged for that as well? Can that be? No, it can't be, because that is a civil matter. Okay, that is the delict right there. The delict is the damages that you caused through your negligent behavior. Okay, you were negligent, you were driving your motor vehicle, you weren't keeping a proper lookout, you foresaw an accident could have happened and you failed to prevent it, and you have caused damages to somebody. Now, that is an example of a delict. You can't go to jail for a delict like you can for the crimes and be punished by the state, but the person who suffered the damages can sue you. So that is an example of a delict. Okay. Now, delict, one of the laws of the delict requires that you must be the one that causes the damage. Right? In that example, that driver caused the damage. You caused the damage to the other person by virtue of your negligent driving. Okay. But you need to be the cause of it. Okay, now the law of delict also says it has a thing known as strict liability. It's like one of the exceptions, to normal liability. It says that when there's a certain relationship between the parties, then the parties will be held, a certain party can be held liable for deeds or things or delicts that are committed because of that relationship. You've got a child, the child breaks the neighbor's front window. Are you going to sue the child? Is the neighbor going to sue the child? Who will the neighbor sue? The neighbor will look towards the parents. All right, because there's a relationship there that the parents will be liable for certain acts of the child. Okay, so we call that strict liability. Now, there's another type of liability which is a form of strict liability known as vicarious liability. And this is the doctrine that we should actually speak of. Okay? Vicarious liability. It is an idea that somebody else will be held liable for the behavior or for the actions of another person, even though the person was not involved or didn't actually cause it himself. You didn't break the window, the neighbor's window, it was your child, but now you're responsible. So vicarious liability says, and it comes into play, and if you can prove an employment relationship, then the employee can be held liable for the actions of the employer, the boss, the company, the organization, can be held liable for the actions of its employees if they commit delicts. Okay, provided certain requirements are met. Okay, and what are those requirements that you must prove? And this is where you're going to get the marks. So you need to in this answer here, you must tell Mr. Riba, look, Mr. Riba, you can hold these parties liable. You can actually hold them both liable. But ideally, you want to hold easy electricians liable because they are the parties with the money. Or by virtue, how are you going to hold them liable? By virtue of the doctrine of vicarious liability, which says that an employee or an employer rather can be held liable for the actions of its employee, provided three requirements are met. These requirements are, in other words, what we need to prove. Mr. Riba needs to prove that Fred is an employee of Easy Electricians. So we must prove that Fred is indeed an employee. He's not an independent contractor. If Fred had to be an independent contractor, then we can't hold Fred liable, or rather we can't hold Easy Electricians, the employer, liable, because he says, well, that's not my employees. These are independent contractors. They should be held liable themselves, not me. So Fred, if we can prove that there's an employment relationship and that the employee committed a delict, what is the delict? The delict is this negligence here, smoking while on duty. Okay, and when he's been told not to smoke, and he's committed a delict during the course and scope of his employment. That's the third requirement. So if Mr. Riba can prove that, then he can hold Easy Electricians liable as well. It's not that he can't hold Fred liable. Fred will also be held liable. They will be what we call joint and severally liable. But ideally, if we can't prove those requirements, then we can't hold Easy Electricians liable. If we can't prove that there's an employment relationship or that Fred committed a delict or that it was during the course and scope of his employment, then we won't be able to hold Easy Electricians liable. And then we can therefore only hold Fred liable. But if we can prove those requirements, then Fred will be liable. So are there any questions on that?
I just wanted to ask, you said that we need to prove that Fred has an employment contract with the
Oh,
electricians, meaning that he should be permanently employed with that company and not a subcontractor of the company.
well, yes. Remember when you started with at the very beginning of the book, they try and explain to you why it is so important to make a distinction between an employee and an independent contractor, right? And how this game is being played in the real world between employers and employees. Because what is there any benefit in being considered an employee?
I'd say yes, there is.
You're right there. Can anybody think what's the benefit? If you've been considered an employee, then you get all the protection of labor laws, right? And that is quite considerable. You know, you get the protection under the Basic Conditions of Employment Act. You get the protections of the Labor Relations Act, which includes the things such as the right not to be unfairly dismissed. Employers just can't get rid of you so simply. Employers got to take so many, so many duties on the employer towards the employee. So you get all this protection, okay, if you are classified as an employee. If you are not considered as an employee, you then don't come under the protection of all the labor laws. You have to get the relief that is normally due to any contracting party in a contractual relationship. Okay, so you want to be considered an employee. And employers realize this, that they can't get rid of employees. Employees take them to the CCMA, and the first thing the CCMA asks them, are you an employee? And the employees will say, employees will say, yes, we believe we are, and they have to just prove that they are an employee. If they can prove that, then they get all the benefits of labor law. They can't prove it, in all these rights that they get, which are in detail in the book, as we will cover over the course. We'll see all the rights that come to employees. So it is greatly beneficial to be an employee. What the employers are doing in the real world is to disguise the contract. Okay, they realize if this is people are considered to be employees of mine, I can't get rid of them so easily. I have to pay them out extra. While they are employed for me, I've got to, make sure that I exercise what we call fair labor practices, no unfair labor practices, no unfair discriminations. If I give the one, I must give the other, all these things. So that won't come to you if you are not an employee. Okay. And there's sometimes the difficulty, it's so difficult, it may sound easy to distinguish between an employer, or an employee rather, and an independent contractor, but what employers are doing is they will make people sign contracts, put terms in their contract saying, well, you know what, you are an independent contractor. But if one examines what they are actually doing, that is the employees, we start to realize, but they are actually not independent contractors. They are actually full-time, proper employees as we understand it. And that has caused that big change in the law. Who knows what big changes has come about in the last couple of years? Okay, so where they've changed the laws, Section 200 capital A of the LRA, and Section 86A of the BCEA, the Basic Conditions of Employment Act, which says that there is now no longer the onus on the employee, the worker, to prove that he is an employee, because employees are doing all kinds of things. Over the years, the courts have brought in different kinds of tests to prove, to try and distinguish, to see, what is the relationship exactly between these parties. Is it an independent contractor? And we know what that happens if that's the case, they don't get any protection under labor laws, or is it an employee relationship? And it will ask different questions. So you must know at least Someone is able to shout out. Okay, put up your hand. The kinds of tests. Name at least a few of the tests that the courts have developed over time to determine whether a party is either an employee. Something. Okay. Can you all hear me? That is strange. I probably just went out and went in again. But can everybody hear me?
Yes.
Yes.
Cool.
Yes.
So we're all following you guys. If you had been going through the beginning here, maybe that is what we can set up. If you guys want, we can set up another session after that. Or a one-on-one. This is a facility UNISA is actually has introduced now. If you're having particular difficulty, understanding different parts of the world, that is where I can perhaps assist you. Now, coming back to the question now. So you, Mr. Riba, what is it, Mr. Riba? Mr. Riba will be advised that he could hold the company particularly liable by virtue of vicarious liability, provided that he can prove those requirements. Okay. No questions further on that, guys? Okay. Now, let me just see here. Now, what will happen as a matter of interest now, just to finish off what I said there, so to complete that part of the picture, is that the law now presumes that there is an employment relationship. Section 200A of the LRA, the Labour Relations Act, and Section 86 of the BCEA have now mentioned explicitly, it says, unless proven otherwise, an employee will be considered to be, a party will be considered to be an employee if one of the following factors are present. So there's a number of factors in the labor laws that says if this is here, then we will assume that the person is not an independent contractor, but is an employee. So these things include things like the person tells you where to do your work, determines your hours of work, controls the work, gives you a working space, all the tests, basically a codification of all the tests that have been developed through the courts over time, which include tests like the organization test, the dominant impression test, which are tests to look at the relationship as a whole. So if one of these factors are present, then no matter what the contract states, if the contract is saying you are going to be an independent contractor, your employer tells you to sign that. Yeah, he's got proof that you've signed it. But the law is saying, despite what you even agree on, it's going to be assumed that if one of these things are there, you are saying that he's an independent contractor, but the person comes to work at hours that you tell him to come to, does the work under your control, determines when he must leave, when he must go, all these things. So if one of those things are there, despite what you say in your contract, the law, however, will presume that you are an employee. And then the onus will move on to the employer now to show that the person is not an employee. Okay, so that's a very significant development in labor law. Okay, which has changed the game for employees. It protects employees a lot more from the exploitative practices of employers, abuse people in the workplace. They make them, put them on short-term contracts, which get renewed every year or every second year, and then they get told, no, you're not actually an employee, you are you're a contractor. But in those situations, it will be clear that the law says that no, although you're saying that it's an independent contractor, the law is assuming that that is an employee relationship, and therefore the person should get the benefit. You must show otherwise as the employer. And once you are an employee, you must be paid you get all the benefits. They can't just dismiss you. They must pay you severance pay. They must make sure that you're not discriminated against. So it's important, as you can see from that. Yes. Did you want to say something, Aisha?
No, I just want to know, like you've now mentioned a lot of things on this first question. So I just want to know, like,
not least the answer, right? I mean, I did say that. I mean, I said a lot of things through, but the answer was in there, that
yes,
you must, what you need to do, right? Yeah, okay.
the civil wrong.
Vicarious liability.
Yes, I know that. I got that part of it, but I just want to know what I want to know is, say for instance, now I answer not everything of the like the dealing part, and answer some of the stuff that you said in the other parts of it, like the employees' rights and so on. Will we get marks for that, or is it only specific to the right part of it? You know what I'm saying?
Yeah, I think I know. I mean, I've given you some background information. It was there for your own edification. But it won't be necessary to go into that detail because you only asked to write 6 marks.
No, I'm just saying, like, what if you go off from just explaining the link and that itself and giving more
delict.
Sorry, delict.
Delict.
Say now you delict.
Yeah, delict. Okay,
so
go on now.
If you just go off a bit from what you're supposed to be giving, and you give a bit of that background in, will you get marks for that, or won't you? Will you just get for
you would get marks, but you won't be. Yes, you would, but now you see, we're looking for that specific thing. So if you mention those 3 requirements, you're going to get probably 4 marks for mentioning the 3 requirements and no more than 2 marks for introducing the concept. Look, this is basically a case of vicarious liability. This is the idea that the employer is going to be held responsible for the employee's actions, even though the employer wasn't the true cause of it, it was his employee. This is because of vicarious liability. So you can hold the employer responsible if you can prove the requirements, and then you mention the requirements.
And obviously, if you, like you said in the beginning, if we just say, like everybody explained what they understand of it, and we don't give the actual delict, I don't know if I'm saying it right. If we don't mention that and the civil wrong, but we're just speaking overview of the question, we'll only get like half of that marks, or maybe 2 marks.
Yeah, the important thing that they want to see is that you can identify vicarious liability, all right, and you can explain that it is because one of the requirements of vicarious liability is that the employee, there is an employee relationship, the employee committed a delict, right? So there you're mentioning that word delict. So therefore, what I would take from this is that you might get, the same question can be for 8 marks.
Yes.
At other universities, I've seen the very same question, not the same wording, but it's 8 marks very commonly, and 6 marks will go on the requirements if you list the requirements.
Okay.
Right, and 2 marks introducing the concept of vicarious liability.
Okay.
Now let's jump ship quickly to the other side. If you're now a lawyer or an advisor for Mr. or Easy Electricians, they're being sued now. First defendant is Easy Electricians, and the second defendant is Fred. Right? You, the plaintiff, Mr. Riba, is suing the 2 of them, and you actually want Easy Electricians to be held liable, and you're telling the court, well, if Easy Electricians, we can't prove that Easy Electricians are liable, then alternatively you want Fred to be held liable. Now, what advice could you give Easy Electricians, okay, in view of the requirements for a delict? What do you think? What weakness is there possibly here in this question? Who can recall the requirements for vicarious liability? There must be an employment relationship, right? Between the employee must have committed a delict, right? Now this is a delict, negligence. And what's the third one?
Careless liability. Is that the same thing?
No.
Careless liability.
The requirements of vicarious liability.
Oh, okay.
I'm telling you now, we're saying these are the requirements, or of to prove vicarious liability or the company liable. You must prove those three things.
Relationship.
Right? There's an employment relationship between Fred and the electric company. That
Yes.
Fred committed a delict. And thirdly, what's the third requirement?
The employee must have acted in the course or scope of his employment.
He must have committed a delict and acted in the course and scope. So what advice could you possibly give Mr. What's this company called? Easy Electricians here now. Because what commonly, employers do in cases like this is they will deny that Fred was acting in the course and scope of his employment. Okay, and there has been cases, where people were doing things or committed delicts, but they weren't acting in the course and scope. Now, the question is, what is the course and scope? Okay, so something you guys can actually have a look at. Would you say that what he did was within the course and scope of his employment? Would say that falls within the course and scope of his employment?
No.
Aisha says no. Okay, why?
No, because he was told he can't smoke, and he did.
But you see, it's not like when there's been case law, guys, and decisions of the courts that said it must be linked to that. In other words, was he not on a job, basically? Was he busy on a job? It's different if it was during his lunch break, or what the courts have called when an employee goes on a frolic of his own. And he starts doing things that he's not supposed to, outside of work, outside even the course and scope of his employment, then the employer can't be held liable. But here he was on the job, doing a job for the company when he did this. Right, so unfortunately, it's not looking too good for the employer here to escape liability. Any further questions on that, guys? No further questions. All right. Shall we move to question 2?
Yes, again.
Okay. Question 2. What general conditions regarding the employment of foreign nationals does the Employment Services Act 4 of 2014 set out? Have you heard of this law, by the way, guys? The Employment Services Act.
Yes.
Okay, and what does it do, basically?
Basically, it protects the rights of foreign nationals.
Yes.
Yes.
You see, there's different categories of employees. Remember, we've established, or you should have definitely have realized when you started reading your material, when you did learning unit 1, how important it is to be classified as an employee, right? It's too many benefits for an employee. So it's like really you want to be classified as one to be able to get all the protection. Now, what about people? You get different kinds of employees. You get fixed term employees, fixed term contract employees, casual employees, get seasonal employees, temps, all these kinds of people. But now remember, the new law, Section 200A of the LRA and 86A of the BCEA, all these BCAs and acronyms, I hope you're not getting lost in it, says that, it puts a presumption. Remember, it makes it presumption there. So if any of those listed requirements are present, a seasonal worker or temp worker may very well be considered to be an employee for all intents and purposes and fall under the Act. But now, what about illegal workers, foreigners especially? So this Act deals especially with foreigners who, and a foreigner is described as somebody who is not a citizen of the country and who doesn't have a work permit. Okay. So one would think, wow, okay, it's forbidden in law now then to employ somebody without a work permit, right? A foreigner without a work permit is someone, the law says if you do it, the Immigration Act says if you employ somebody who is a foreigner, that is, he's not a citizen and he doesn't have a permit to be here, then you, the employer, is going to be held liable for employing such a person. Okay. Well, what do we do? So this Act has come in to protect these classes of people. It's trying to regulate employment in the country and give opportunities to South African citizens. So it doesn't prohibit us to employ foreigners. It says a foreigner can be employed provided they have a work permit. And even if they don't have a work permit, it doesn't mean that you can exploit them. Number one, if you are an employer and you employ one, you're going to be in trouble. You're going to have to pay some big fine. One. Two, they don't have the protection of the LRA and the BCEA and the EEA, the Employment Equity Act, all these labor laws, because they're not considered employees. They can't be employees by virtue of not having work permits. But they still, as people resident in the country or just being in this country under this law, every person has the right to certain labor rights. Okay, you get protection not under the labor laws, but you get protection under the Constitution. And Section 23 says that everyone has the right to fair labor practices. So a foreigner that has been working here illegally for so many years, whatever the case may be, the employer is in trouble for doing that. The employer now thinks that it is not obliged to pay this foreign worker and refuses to pay. The employer will now be in trouble, and the employee can't take the matter to the CCMA or to the other options open to him as a normal employee. But the employee, being a foreign employee, gets protection under the Constitution and can still hold the employer liable for what is owed to him, okay, for compensation, but not as an employee under the labor laws of the country. Is any questions about that? So that 3-mark question, guys, is simply somebody's already answered it. It deals with, regulating employment of foreign nationals and wants to give opportunities to unskilled workers, unskilled South African workers, by preferring them above foreign nationals, basically. And foreign nationals can be employed, provided they meet our laws, which are that, there must be such a shortfall of that particular skill that is why you called upon someone other than a citizen to do the job. Okay, so special protection. This is what we call vulnerable workers. Okay, foreign workers were considered vulnerable. And then you guys may want to look at the Kylie case. Who's read the Kylie case? Kylie versus CCMA and others. Okay, where the same principle was adopted, basically. Kylie was a prostitute, and she was abused in the sense that she had rendered services and was not paid for that. And is she considered an employee under our law, under labor laws? No, because say again.
No, I just said no. Sorry.
Oh yeah, no, right. Because our law doesn't recognize, considers that to be an immoral contract and not enforceable. So what does this now mean, that you're free to abuse people in that situation and they can't get any kind of compensation? The law said no. You know, everybody's got the right to decency, to dignity rather, the right to dignity, and the right to labor, to fair labor practices. She's not an employee. She can't go to the CCMA or rely on the LRA or the BCEA or any other law under labor, but she can definitely rely on the constitutional right of the right to fair labor practices, and she was compensated something for the person who had employed her. Okay. An interesting case, Kylie versus CCMA. So the long and short of it is, people like foreign workers and illegal workers and so on won't get protection under our labor laws. And when we speak of labor laws, we speak of the commonly, known laws that protect, that we look for protection under as workers. They won't fall under that. That is dealt with in a particular way, but she won't fall under that. She will fall under just a party who has a right to have a side heard and to be compensated and not to be abused, and to fair labor practices, which is a constitutional right. Okay. I hope that's clear, guys. Any questions? Everybody's very quiet over there. What's up? It's like is this helping, guys, or do you think that if there's anything you don't understand, please, you must speak up? Or is it a question of, well, we didn't cover the work in that detail and that way at that time?
From my side, I'm happy. I'm happy.
You see, guys, that is where we're coming to, how to approach this work. And that is what the this is now. Perhaps I can. Here's my slides, by the way. I have slides over here somewhere. Okay, there's a feedback form, guys. Do you see it there?
Yes.
Yes, I do.
You make use of that, yeah. Let's take a short break just for you guys to, to fill that in quickly. Because the admin center, Adele and the team there, they be able to, okay. As
Rayan,
yes.
I just want to remind students again also to complete the evaluation form that I've just posted.
Yes.
Okay, and if students cannot, like Lizzie, cannot access the register, then it's fine if your student number is here in the chat. Okay, thanks, Rayan.
Thank you, Adele. No worries. Okay, so this is, perhaps, guys, now that we've discussed a few questions, perhaps it's time for me just to, make a suggestion about how you approach the UNISA work here. They start out, I mean, it's like 6 or 7 learning units here. Okay. Okay. Just put your hands up if you can hear me. I just had another network issue, so just raise your hand over there, okay, if you can hear me. Only 2 people can hear me. Okay, 3 people. Cool. So I think you can all hear me. Look, the thing is, many students, when they start off and they start studying the work, is that they break the work up into learning units that they will cover over a period for the semester, right? So if there's like 10-year learning units in the course or in the module, they look at it, they divide it over the period. So they say, well, for the next 2 weeks, I'm going to cover learning unit 1 and 2. After that, I will cover learning units 3 and 4. And, they work it out so that hopefully before the exam comes to an end, they've covered everything, right? And whatever time remains, they're now going to revise and prepare to write the exam. Hands up if you follow this particular method. Okay, Mbasa, right? Okay, the others are not. So what methods do you guys follow then, who don't follow this method? Okay, Fatima also does it. Okay, so the thing is, this is a very common method used by many students, and it may work for some of you, but I'm finding that the majority of students, experience difficulties with this, because what happens is this is on the assumption that you have enough time, that nothing will happen, between now and the exam. It doesn't always take into account contingencies, things that happen that you don't foresee, right? And many times people end up not well prepared for the exam. It's because they take piece by piece. They start at the beginning, hoping to reach the end. Other method, very common method also, I don't know if it's common in this group, but is for some people, they cram everything in a few weeks before, and sometimes even days before the exam, and intensely prepare and hope to do well. Okay. And that is a high risk method. You're really gambling there, and that can particularly, come out to a reaction like this, especially if you've done a few subjects, a number of subjects, and realize that you've bitten off more than you can chew. Okay, and I've seen this method not working for many people. So I like to think that if you manage your time properly, you can be successful. Like this gentleman here, Nelson Mandela was on Robben Island when doing his completing his LLB. Okay, so I'm moving my slides quicker because the point I want to get to is this approach to your studies, and I would advise you perhaps to just consider this. The UNISA lecturers are few and the students are many. They have only so much time themselves. They therefore have to present material in a very particular way. In fact, most modern courses now, online courses especially, are designed on the old UNISA module. Okay, UNISA was never a face-to-face institution in the sense that you would attend lectures every day. You would basically start of one academic year, which would be an entire year, which would begin around about February or March and end off in October, November. And you would be given textbooks. You'd be given tutorial letters and study guides once you've registered and do an assignment. You have to buy textbooks. Depending how well you performed in your assignment, you'd qualify. You would have to qualify to sit for the exam. And once you have qualified to sit for the exam, you write the exam. Nobody there to really help you much. Okay. You could call up your lecturer in Pretoria, but it wasn't always a guarantee to get them. You could write them letters or faxes. Okay, so that was the classic UNISA way of doing things before technology really hopped in. Okay, so technology has now come up. You can get hold of a lecturer, like in a forum such as this. So there's a lot more, easier methods that are making it easier for students. But nonetheless, you must understand what difficulties the lecturers also have in trying to teach a first, a second, a third, or even a fourth year subject. So they are limited, like all teachers would be limited in terms of what they can teach and how they can respond to students. So my suggestion is to do the following, okay? You get an overview and outline of the course in the learning units. Like here, this is LLW2601. It's like 6 or 7 units. I don't know how more they've broken this up, but it's covering material, okay? And you must get a sense of what they're trying to teach. You look at the learning outcomes. They tell you what they're hoping to achieve if you study the material well. You must be able to acquire the label or knowledge about it, and to such an extent that you become proficient enough to be able to even give advice and to talk about it critically, okay, and to apply it in practical situations. So I say to students, especially those who've got more than one course, to write out an overview, draw an outline of the course and the learning, and so you know what you need to cover for your semester. And with UNISA very generously tells you, especially in the law subjects, that look, don't worry with chapters this, that, and the other in your textbook. So you eliminate that from your outline. So it's there, but it's not being required to study it carefully for the exam. So you know what to exclude. Then you have this map that you put out there, and you put it near your study area. You paste it on a one-page document. Ideally, if you can, for every course that you registered for, have a mind map for every course, and you put that in your study area. Then anytime when you go to your study area or when you walk past there, okay, that is, I need to cover that. You have a very good idea about what you still need to cover and where you're short. So once you know what the outline of the course is, instead of waiting, to go through it week by week, rather go through the entire course and what I would call a cycle. Okay, it might be daunting at first, but it will help you to get an idea. The whole idea of going through the material in one cycle tells you where your beginning is and what your end is. If you're going to use the method that many students use, going bit by bit, they may not even know what is at the end. But if they start at the beginning and go through right till the end, they'll know what the course is about. At least they'll have some idea what it is about. Okay, don't do the previous method where you've covered a few learning units, something happened, you're not able to prepare, but no idea what the end learning units are about. So go through it through, the cycle manner, the cycle method. And in this first cycle, you're going to prepare a skeleton structure of the course material. And you just you add basically small amounts to your skeletal structure of the course. And you do another cycle, and to your next cycle, you'll add the so-called flesh to the bones. You improve your understanding of the material, and you find you're going to come across concepts that you may not understand at first. And that is the trick here. Some of these concepts, like you didn't understand vicarious liability this evening. Okay, you heard about it, you didn't know how to connect it, but if you regularly visit it, even in passing, you're going to remember eventually what it means. You need to keep going through the material from the first beginning learning units till the end of the last learning units. And as you go through every cycle, you add more notes, and you will then start to improve your understanding of everything. Okay. These notes will be peculiar to you. You'll know what they mean. You will leave little openings where you have difficulties. Like if you had started in learning unit 1, you may have come across the term vicarious liability, but you didn't perhaps understand it like you didn't know tonight. So it was explained in detail this occasion. And when you come to further on in the learning unit, the restraints of you've heard about it with a rough idea, but it's not time to add that part of me to it just yet. Okay. You keep adding and you keep adding and you're going through through the doing your cycles, and you get the holistic understanding of every of the course. Okay, and this approach is very helpful. I've had students over the years thanking me for it. I found it to be helpful as well. Any questions on that, guys? Any questions so far on this method, guys?
No,
Fatima,
sir.
yeah, I think, I don't know if you were in my class before, I may have spoken about this.
So as I mentioned about the mind map, and then there was an app, Simple Mind, I think it was called.
Yes, okay, yes.
So I have been using that.
And how have you found that?
Quite useful.
Awesome, that's good. Look, the thing is, this is like this module for this semester. Your entire degree, you guys are BCom students, eh? Are you all BCom students?
Yes.
Yes.
Right. So to get your BCom degree,
No.
you need 30. You're not. Lizzie, what are you doing?
Yes.
No.
Who's not doing it?
I'm doing my
I'm doing LLB. Just
Okay.
LLB.
LLB,
I'm
eh?
doing
And
I'm
you're
doing a
doing what?
diploma.
Oh,
A diploma.
Okay.
Yes.
So while there's an LLB student here this evening, that's a 4-year course, and the others are all BCom, probably majoring in commercial law, right? Now, look, for your BCom, you're going to need 32 subjects, right? Over 3 years. For your BCom, or your LLB, you're going to need 40 modules. That's 32 plus 8 electives. So that's the minimum time you can do that is 4 years, right? So that's your degree right there. If you can put down 40 mind maps on your study area, okay? If you want to achieve mastery in all your subjects, that is that over there. Yeah? That wall you can put 40 pages, and that is your subject there. Because the idea is, after all the study of law for 3-4 years and more, you are required to put this all together to make sense of it. I know when you start out, it's very difficult. These concepts are so far removed, hard to understand. But if you keep an overview of everything at all times, right, you won't easily get lost in everything. And you'll know where to focus when focus is required. Okay. And what you're also going to realize is that all these 40 subjects, they overlap. Everything overlaps in law. Law is just, has been classified by academics and so on, the study of law. But if you can make sense of all of that, put up your 32 mind maps, your 32 outlines. Oh, that's my degree on the wall over there. Right. That's my LLB, the 40 outlines over there. And in each outline, I can see what we're required to cover, where that particular sub area connects with another sub area in another subject. And that is going to be your challenge as law students going forward. Mr. Abrams, John, is that you?
Hi, Rian. I'm just.
Hi, evening, John.
Yes. I'm good yourself.
Well, thank you. Well, thank you.
Yeah. And enjoy the class. Enjoy the class, students.
Okay. No, thanks, John. If he hangs around, that's cool. So that is what I'm telling you there. That is how you know from experience, and I've tried this with students. You know, students who started off, you know, just a few years after I was admitted as an attorney, and later on I saw them, and I do see them in practice. They've, you know, progressed so well in their studies that they've completed their degrees, they've entered the profession, either as advocates or attorneys. And, you know, when we would have a chance to talk about this, you know, it's the approach to the information that is such an effective tool, you know, that we can agree on. So, guys, adapt it. I'm sure you'll see benefits. Okay. Any further questions on that? No. Okay. Let's go back. Shall we go back to another question before we can call it a day? We have 15 minutes left, guys. Why don't we try and do question 3? Shall we do question 3?
Yes.
Yes.
The only one, Aisha and I think Lizzie. The others are, you know,
Yes, we
they
can.
feel
Yes.
that.
Yes, we can hear you.
Oh yes, good.
Yeah.
That's the attitude. You see, that's the attitude because, you know what, man. You know, when I did the subject, it was like a year course, right? We had the year to think over things, and also if you failed at the end of the year, you had wasted a year. Yeah, they've, you know, in the last 15 years, they were not 25 years. 20 years, they've changed it into half semesters, okay? And they've shortened the time periods, the time for exams to be written. It used to be 3 hours, it's about 2 hours, it's still for 100 marks. And the questions are long questions, but short, you know, the mark allocation is less. So there's even a different way in which they examine and test students. So you must be alive to that, and how you can use that to your advantage. Okay, nobody here is going to be presented with a question paper of containing 4 questions for 25 marks, because that is pretty much how, you know, a mercantile law paper like labor law used to look like, you know, in those days. 4 questions, 25 marks each, or 5 questions, 20 marks. So that has all changed. They don't examine people like that hardly anymore, not in these subjects. Now, let's go back to question 3 now. Okay, who's going to read this for me? I've been talking for so long that I think somebody else should now read for me. Question 3. Who will read it for me?
Okay, I can read.
I would appreciate that.
Yes. Villa is employed by an IT company in Gauteng. Villa has not done any work for the 3 months that he has been with the company, and he is even thinking that his manager is intentionally ignoring him. This has been the case even though Villa has been to work every single day of the week as required by his contract of employment. Yes.
Continue.
Discuss whether the company should continue paying Villa his full salary even though he's not doing any work.
Yes. Could be an employee at the city council. Now, yes, what subject area is this about, guys? Is anybody any clue? Where in the material, in the textbook and in the studies, where have you seen this? Under what area does it fall?
It still falls under Employment Act, under labor law, like the employment relationship. That's what we're still looking at. So you also refer to the basic conditions of employment in the Labor Relations Act.
Now remember, you know, there's also this thing called common law. Remember,
Yes.
in your earlier studies in Commercial Law 1, Fatima, you may recall, there's this thing called the common law. All right, the common law, what is that? Who can remember what that is? I remember the common law before the BCEA and before the LRA and the EEA and all these various labor laws. what was there? Okay, there were other statutes as well, but they were replaced by this new, constitutional era legislation. But even before the statutes were passed, we followed the common law, which was a mixture of Roman Dutch law and English law. That was actually the law that we followed, the common law, the Roman Dutch law writings. And that would be the backbone of our contract law. And employment is only but another type of a contract. There are various kinds of contracts, one of the many of which is an employment contract, okay? The common law. The common law has been altered now from that time. I mean, we now have the current age, in the constitutional era, we've got all these laws that have amended the common law. Okay, it hasn't done away with it, but it has amended it and made it now the standard law. But what this question is covering, guys, is the common law duty now of what an employee, should do. And you don't give them work, but the employee reports for duty, then must you continue paying that employee? Okay. Now, if you look at the duties in any contract, there's duties and obligations on both parties. The employer under common law has got the duty to pay the employee rather, to provide the employee with work, to provide safe working conditions, and also to be fair to the employee. The employee, on the other hand, what must he do? He must render the services that he's been contracted to do, and he must do his job competently, diligently, and he must obey lawful and reasonable instructions, and he must also serve the employee in good faith. These are the common law duties. Okay? The labor laws that we have today have sort of made that, very clear what the duties of the employer on the one hand and the employee on the other hand is. Now, we're honing in now on those duties. One of the duties is the duty from the employer side is to provide the employee with work. Okay? If the employer must take the employee into service. In other words, start making him work. Once he's done that, then it is the employer's duty to provide work. If the employer does not provide work, the employee cannot be held responsible for that, even if the employee does nothing. The employer is still obliged to pay the employee. Okay? But once the employer provides the work, the employee is duty-bound to carry out all those instructions and to do all that work. Failure to do that will open it up now, to discipline the employee. Okay? So in this case here now, should the company continue paying Vila his full salary even though he's not doing any work? Guys,
Yes.
what do you think? Yes. Yes. It's not Vila's fault. If Vila is given the work and then refuses, that's a different story. But the duty of the employer is to make the work available. Okay. It is not the employee's fault. It is the employer's responsibility. The only time when there's an exception to this is when you employ somebody, perhaps when the job is commission based, when you're saying, look, your salary will be paid from the amount of units that you sell, for example. But the employer doesn't make these units available, so now it's impossible for him to generate an income now as a remuneration. Yeah, but generally, you need to provide the work as the employer, and the employee must carry out instructions diligently, in good faith, to be able to be paid. But if you don't do it, if you don't make it available, then you have to pay the employee nonetheless. Not a difficult question, guys. This is an easier one. Are there any further questions on that? Okay, if you want extra marks, there has been changes in law, like the National Minimum Wage Act, which stipulates the minimum amount of that must be paid to certain categories of workers. Okay, you can't pay less than that, and that act is read together with the BCEA, which now regulates the working conditions and so forth. Any questions on this one? No. Okay. Now I'm going to give you. I'm going to discuss the next question, and in the following session, I would like for you guys to come and present me with your answers. How about that? Question 4. X works for a municipality as a typist. Okay? X's manager Y always insulted him by calling him an idiot. At one stage, Y told X that he did not even like him. As a result, X resigned. Discuss whether, in your view, X will be able to succeed with a claim of constructive dismissal. Okay. Now remember, have you followed? Who's heard of this term, constructive dismissal? Dismissal is right in the law study unit, guys. And had you now done the cycle approach of studying, you would have known that this term exists. You may not have known what it meant, but at least you knew there was a reference to this term of constructive dismissal. Who's got any idea what it is?
Shall I say something?
Yes, please do.
It's when, okay, I've heard about it. It's when you make the working environment unbearable for the employee to the extent that they end up resigning. That's basically it. Where the environment actually forces the employee to opt to rather leave the company, not because they really wanted to resign. They feel they didn't have any other choice.
Exactly. That is, you're pretty much close there. You're very, very close there. Where the employer, when the person leaves, there's a section in the Labor Relations Act, okay, which deals with the definition of a dismissal. Because remember, one of the requirements, one of the protections that you have, one of the protections that you as an employee have under the Basic Conditions Employment Act and under the Labor Relations Act is that that you have the right not to be unfairly dismissed. Okay. If you have a contract and the contract says, well, I can give you 30 days notice. Okay, so you've been working for a while, maybe a year or two. Boss comes to you with a notice. He says, well, you've got 30 days. Here's your notice, eh? Thanks for your time here. You'll get your last paycheck, and we'll also pay you out whatever leave and those kinds of monies that we owe you. You say thank you, and you wait for it. You go look for another job. Is there anything wrong with that situation?
Yes and no.
Yes and no. Okay. Explain.
So if it's a mutual agreement whereby I as the employer take the initiative and say I'm resigning, that's where I serve notice, and the employer is liable to give me my last paycheck in the following month, depending on the cutoff. And if it's because I've been ill-treated, it means that my rights and my freedom has been infringed. So that does not equate to what I have had to go through. There's something that I read about in the book that said it's not acceptable, but it is a method that helps the employer reach an agreement with the employee.
So now that is one of the most common mistakes or misconceptions that people generally have. They think that because the contract stipulates that either party may give the other one notice, of termination. Because notice of termination is basically when, what are you doing? You're ending the contract, and you can't do that in terms of the LRA unless you have good reason. Okay, you cannot simply give the person the notice, which in effect is a termination, cancellation of a contract, which you cannot do in labor law to an employee, because the employee has the right not to be unfairly dismissed. And this means that you cannot dismiss an employee, unless it is substantively and procedurally fairly done. In other words, substantively, it must be a good reason, a recognized reason in law, and secondly, procedurally, even if you may have a good reason, you still need to follow a lawful procedure, proper hearing process. Hear the other side. Now, go and look at section 186, subsection 1, subsection E of the LRA for next time, and then we will discuss it further. We are out of time now. Okay. Have you all completed the online evaluation forms there that Adele put up over there?
Yes, but I wasn't able to sign the register, but I did put my student number in the meeting chat.
Okay, that's, I think, okay. Is that okay, Adele? All right. And then there's also the, okay, so you've done all of that. If that's cool, then, you can start setting up sessions, or you can request sessions. Well, I can't do that yet until I get my license, apparently, or my own login details into Teams from UNISA. I have my own login details from other organizations, but not for UNISA. And I think it's better if I get a login here or channel here, from UNISA. And from there, we can set up any. Is there anybody who's interested in perhaps wanting a session on a particular area of the work? Or you guys, what do you think? Well, the option is open. We meet again next week, Monday. Okay. We would continue to work through the work, and if you're struggling, you can request a session. Okay, and then that can be set up. Okay. Adele, are you there? She seems to be busy somewhere else. But yeah, I think.
Sorry, do you need assistance? Is John here? Do you need assistance with something?
Yeah, no, we've just finished up here now. And like I told the students that, they can book sessions, and they could probably do that better once I get my own channel, UNISA on Teams.
Okay.
My own,
I will